Or it could be somebody like Brian Brooks, who would be even better, who's very much more crypto native. I'm hearing people speculate Brian Brooks could be the SEC chairman, which I'm saying prayers
That
for
would be
the
amazing.
year or two. Brian Brooks, Chairman Brooks. I mean, that could be the messianic moment in our movement. Um, so it could all work out.
This content is brought to you by BitGo, which is one of the top crypto custodians in the crypto industry. BitGo works with many big companies and brands such as Pantera Capital, Bitstamp, and Bitcoin IRA. Nike also selected BitGo to power its wallets for its NFTs. And BitGo has many great services such as hot wallets, custodial wallets, self-managed cold wallets, and NFT wallets. Many institutions trust BitGo with its top-level security and incredible services such as being able to deploy your capital while it's in custody, which includes lending, borrowing, trading, staking, DeFi access, and more. If you'd like to learn more about BitGo, please visit bitgo.com, link in the description. Welcome to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me today is JW Verret, who is a crypto law professor of accounting and corporate/securities law. JW, great to have you back on.
Good to be here, Tony. Thanks, man.
JW, we've spoken over the years and talked about crypto regulations and the SEC and much more. And the battle continues. There's so many layers to what's been happening with crypto and politics and the courts. I'd love to, though, start with the Bitcoin ETFs because that's, a huge milestone for the market, and it came at the defeat of Gary Gensler and the SEC. What are your thoughts on the Bitcoin spot ETF performance?
It's great. I mean, it so far it's obviously a bull signal for Bitcoin. I love that. My bags love that. Um, it helps with institutional adoption. Obviously, we've been waiting for that for a long time. I do hear the views of some who are concerned about this kind of institutionalization of Bitcoin. I don't think the sky is falling yet, but I do hear the concern that what if one day the future of Bitcoin is everything's held by some kind of a custodian and the laws evolve to make it hard to use Bitcoin natively and custody, self-custody, and use for peer-to-peer transactions. That's not a future that's any good. That's not a future where Bitcoin is useful, really, because the whole point of Bitcoin is decentralized, permissionless transactions. So I hear worries about the threats to that future. I think we should keep an eye on it. I think we should make sure that, the right to permissionless peer-to-peer transactions is held sacrosanct everywhere in the law. But for now, it's a good bull signal, so I'll take the good news. I'll take the win.
Yeah, look, and I've also, well, I should say, I've been struggling with this because it is a double-edged sword. One hand, like you said, our bags look great, it's bullish, but then you lose a lot of the principles of and benefits of Bitcoin. And to your point, if it's all locked up in ETFs and the majority of the population go that direction, is it easy for them to confiscate it and much more, right? And limit what we can do with it. So I am concerned about that, but like you said, we'll have to wait and see.
Yeah, and it's the ETF by itself doesn't bring us to that future. If people, if even if most of the world accesses Bitcoin in that way, as long as you and I have the right to a peer-to-peer transaction, the Bitcoin blockchain, we're fine. And there'll always be, I think, some of us who do it that way. What I worry about is a future where merchants are prohibited from accepting it as payment, or where the tax laws continue to be a headwind. We need to fix for that a de minimis exemption from capital gains tax for using Bitcoin the way it's meant to be used, stuff like that. Another thing I'm keeping an eye on is recently a settlement in Florida that a prosecutor by the name of Chris Brown brought a case against someone. They get 5 years in prison. Guess for what? Not selling drugs, not any crime of violence. They were a large user of local Bitcoin. That's it.
Wow.
Uh, Buying and selling $4 or $5 million worth of Bitcoin on local Bitcoin. And they said, you're an unlicensed money transmitter, fella. You're going to jail for 5 years. That kind of stuff is really what scares me.
So JW, could it a mock scenario? My cousin wants to buy some Bitcoin. I have a good stash. I'm like, you know what? Hey, buy some from me. I'll give it to you at a discount versus the market. Could I get in trouble for that?
No, no. So what they got him for was he's going on. He's got a heavy bags. He's a whale. Uh, and he's going on local Bitcoin buying and selling.
Hmm.
And he said, "Look, that's what I do. I'm speculating. I don't want to go in Coinbase. I want to do this here." They said, "No, you're in the business of money transmission. You're not buying and selling for yourself. You're doing it for other people and making money off of being a exchanger of money, basically." Yeah, that's a wide gray area between those two things. And to hit you with a statute created for Western Union and to say you're just like Western Union too, just because you're a whale user on local Bitcoin, that's my worry. Um, and I think it's wrong. I think it's just wrong.
That's wild. Yeah. I mean, so I can't buy I just think of it as okay, I go buy a bunch of fruit or something from someplace and I sell it to my neighbors or something. I'm going to be in trouble to be like some sort of produce
That's,
supplier.
that's the analogy. Yeah.
Wow, incredible. Now there's a race for the Ethereum spot ETF, but there's a lot of complications with that because there's reports that the SEC is looking to classify ETH as a security. You layer in what Rostin Benham, chair of the CFTC, recently said in a testimony about Prometheum custodying Ethereum as a security. The SEC gave it the green license for that, or the green light, excuse me. And everyone is saying this ETH ETF situation, it doesn't look good. I would love to get your thoughts on the SEC trying to classify it as security and the ETF approval chances.
Well, I think long term we're going to win this fight, same way we won the Bitcoin fight. Short term, I think Gary's going to be Gary,
Mm.
and we're going to see the same obstinance. He's going to say, "Take us to court." Eventually, we'll win there on the same grounds because the case is close enough, analogous enough. So we'll have to fight that fight. It'll be unfortunate if you're trying to make an Ethereum play that in the next 6 months we have ETF approval, you're going to lose on that. But if you're buying Ethereum for the right reasons, betting on a future 5, 10 years from now where Ethereum is the base layer for a lot of finance, um, then I think you'll be well rewarded for holding through a long-term fight on the ETF.
Yeah, for sure. Do you think they have any legs with the security piece? Because it's obviously it's a mess, right? And the SEC is throwing anything at the wall, it seems like, to try to make it stick. Uh, but like, you had the Bill Hinman situation under Jay Clayton, not a security. The market has been moving forward, but all of a sudden, Gensler is, I don't know if he's playing games or what he's doing, but do you think there's anything there?
It depends on your interpretation of the Howey test and federal securities laws. I think the dominant one for most circuits and the one that makes the most sense is just because it's sold as part of a securities transaction doesn't mean the thing itself is a security. The oranges and Howey were securities. So just because in some circumstance or other a transaction in Ethereum is categorized as a securities transaction, that doesn't make it generally speaking a security. So I think we're good there. I think we're still good there.
Mhm.
We'll see what happens with any particular case. I'm troubled as anyone by the news that someone sent a subpoena to the Ethereum Foundation. Now that's not the end of the world. I'm a lawyer, so subpoenas flying back and forth all the time. Every time I testify in court, I get a subpoena to go do that. Um, I don't think that Ethereum Foundation is probably the target. I think that probably the SEC is building something, maybe even getting its defense ready for when it denies the Ethereum ETF.
Mm.
Uh, but it's something to keep an eye on. But generally speaking, I'm not worried that there'll be some system-wide categorization of ETH as a security. I don't think that has legs.
Yeah, I'm in agreement with you because it seems more like a smokescreen or delay tactic, right? To try to delay the ETF. But we'll see. I think, like you said, industry is going to have to take Gary to court again and beat him there. And maybe that's a good thing because it'll force Congress to work and to get things going.
Yeah, and listen, we've got some of the best lawyers in the world in this industry. I mean, the team at Grayscale, Craig Sawyer at Grayscale, Paul Garrall at Coinbase. These are some of the top lawyers in the world. So I'm betting on our team.
For sure. Now, Speaking of Paul Grewal, you had the Coinbase a ruling just I think it was last week where it looks like this is going to go into discovery. I would love to get your thoughts on that case and what outcome you see happening there.
Well, it was a disappointing case. Look, ultimately, I the headwinds are against us in federal district court, in federal appellate court on how we test application. It's a vague, flexible test. It just is. I was hoping the argument that you need to have contractual privity for something to be a security to work out, but the odds were it wasn't going to work out, and it didn't in that case. The hope is Supreme Court. Always has been. The Ripple case was a great case. Don't get me wrong. I'll take the 90% win we got in that case. I
Sure.
love it. I don't know if it'll survive a Second Circuit. We'll try. I'll do an amicus brief, just like the rest of the industry, to support and help and fight for this. But I think ultimately where we win, the final boss, is Supreme Court. Because
Wow.
it's a small thing for them to look back on Howey interpretations and say, you know what? Let's regear a little bit. This test was not intended for this new class of assets, of ownership, of code. That's a small thing for them to do, and I could see that happening at that stage. Until then, headwinds are against us, but don't lose hope, because I think it's at Supreme Court we have hope. And another thing in that the not in that case, but that came about in the Luna Terra case
Mm.
at district court was a finding that the major questions doctrine does not apply. Well, no federal district court is going to do that. That's hitting the nuclear button on the SEC. Only the Supreme Court's going to do that. That's their doctrine, and now it's starting to seep in a little bit. Every once in a while, you get a federal judge willing to use that to rein in an agency, but the magic with that doctrine really happens at Supreme Court level too.
Mm. Question on that Howey test update. Do you foresee a special Howey test created for digital assets as an amendment or something, or it's just the entire test is updated and there's a new category within that for digital assets?
It would be enough just to bang at Howey on the edges
Mm.
and say, for example, go back to some of the language in the original test that looked to profits coming solely from the efforts of a promoter or a third party. Now the test has become if the benefit to the buyer comes significantly from anybody else in an ecosystem. So that has grown much wider than the original case intended. So even if they just put some of that back into Pandora's box a little bit and say, let's hew more toward efforts of the benefit solely coming, or even just mostly coming from a promoter or a third party who the buyer knew about, not necessarily require there to be contractual privity between the promoter or third party, although that would be a good constraint as well. But even just that they knew that they existed, that they knew something about representation that they had made, rather than having people who joined a DAO long after I bought this thing suddenly meeting that element of the test just because they're blogging about it and they're involved in transactions to get a piece of the airdrop, and having that kind of wide definition of anything in the ecosystem fitting that final element of the Howey test. That I wouldn't even call overturning prior precedent. I would just call it kind of an updated interpretation of prior precedent. Surely we can get there.
It looks like this has to go to the Supreme Court, but could Congress act sooner than that and we
They
get proper
could,
legislation?
they could, but they won't. They won't. I mean, I appreciate that Blockchain Association and uh, other groups are active on the Hill on this stuff. You got to play defense,
Sure.
but they won't. And next Congress, it looks likely that we'll have another split between the House and the Senate the other way, a D House and an R Senate. So they're not going to pass anything significant then either.
Dumb question for you. Do you think let's say Biden's out and we get a Republican president in and whatever it may be, Can an executive order be done for crypto, or would that be too much?
Well, that wouldn't last into the next administration, but hopefully, if we have an SEC chairman um, that's friendly to crypto, or at least reasonable and balanced on this, they have more than enough exemptive authority under the law to say, okay, we're creating a new exemption from registration for crypto securities. Here's what it is. Maybe do a little bit of disclosure, but you miss most of all the things that don't fit and and for which crypto cannot comply. It is literally impossible to comply. We're giving you an exemption from those things. I could help them and some of the crew from, from the DeFi law community and folks at Paradigm and who've done white papers and stuff on this. We could draft that in a month and
Hmm.
get that adopted pretty quick. And that would last into future administrations. If somebody later tries to get rid of it, you could use reliance on that regime as I think, a get out of jail free card afterwards, even if a new Gary, God forbid, comes in 2028 or something. So yeah, an SEC chairman can do it by themselves.
Hmm. So I saw you post about the fine that the SEC is trying to get from Ripple, I think $2 billion. You were saying how that's, clear overreach. Tell us about
Technical term is crazy town.
that. Do you think they're just raising the number as high as possible so they can try to get as much as possible?
Yeah, it's punitive.
Mhm.
And this is a common trick the SEC does, which threatens the rule of law. If you compare what the SEC seeks, or you compare what they claim in the universe of cases that are where this allegation is solely unregistered sales. You didn't register your sales. You didn't fraud. You didn't defraud anyone. It wasn't a Ponzi scheme. It wasn't anything nefarious. It was just an unregistered sale. Um, the SEC collects about 11% of what it claims was raised.
Hmm.
So if you went by that number, they would get 11%. But they were initially seeking a couple $100 million, and they just jacked it up to 2 billion. I think punitively because of the level of fight that Ripple has in the sand inside a Garlinghouse, which is that guy's a fighter, man. He's a warrior. This is punitive. This is about that. This is about sending a message. This is about revenge. And it calls the legitimacy of an agency I care a lot about into question. And that's what's really sad about that.
So JW, let's talk about that reputation because it's unbelievable. In the debt box case, they get sanctioned. Obviously, the Grayscale lawsuit, they got called arbitrary and capricious. Even the Ripple lawsuit, Sarah Netburn, highlighted, hey, you don't have allegiance to the law. And I'm like, how can a government agency operate like this? Is it they've become too politicized and maybe it's what Congressman Warren Davidson put together. They need to restructure. There needs to be a change here.
Yeah, it's a runaway agency. Look, I listened to at an event called SEC Speaks last week, where all the SEC lawyers come together and heads of divisions and stuff at the SEC come together and speak to rooms full of compliance lawyers and defense lawyers in the securities bar. Um, as a libertarian securities law guy, it's a tough event for me because I want to just, I mean, you can see my face going red for most of this thing, right? I disagree strongly with these folks on a lot of issues because I think they should be focused on real fraud and they should bring good cases instead of the foot fault stuff and the kind of perspective of a plaintiff lawyer they have of there's a deep pocket, let's go grab something
Mm.
from it. We haven't taxed JP Morgan today. Let's go get $100 million settlement for some silly thing like using Signal or something. Um, the director of enforcement gave a speech,
Mm.
but you wouldn't know from the speech that that was, I guess, an apology for Deadbox. He used a phrase: "We shouldn't let our zeal, as enforcement lawyers, we shouldn't let our zeal, our passion, get ahead of us." Which is kind of one of those non-apology apologies that my kids give when they get in a fight with their brothers. They're like, "I'm sorry, but I'm not sorry."
All right.
Uh, the tone of that was just unprofessional, I think, from the director of the enforcement division of the SEC. I think an unequivocal apology is the only thing you can do for for what someone did, what someone got away with in the debt box case, how that was similar to some of the misconduct in the Ripple case. It's a pattern, and it's a pattern that results from tone at the top, bad tone at the top. The SEC would never let a company defendant get away with the no apology that this director of enforcement gave. That hypocrisy is clear, and it's unprofessional, and it does violence to the agency and its reputation.
Yeah, absolutely. So we're seeing, though, as a result of all this mess, the industry is going on the offensive. We got Coinbase suing the SEC, Kraken suing the SEC. There's smaller companies. I just spoke to someone at the DeFi Education Fund. They're suing the SEC.
Yeah, they're doing. That's a great case.
Yeah, Legilex out of Texas is suing the SEC. Do you think this is the way forward? Because you kind of have to punch back at the bully and tie them up a bit.
Absolutely, absolutely. And 2 or 3 years ago, when Lummis Gillibrand was just coming up, was just being cooked, and when SBF was still on the scene, he was trying to push something called the DCCPA, a bill that would put the commodities regulator in charge of everything. I and a few other voices, folks like Gabe Shapiro, who's a leader, just a thought leader in this space, I respect a lot. A few of us in the wilderness were saying, number one, legislation is not going to happen. You're wasting your time. Number two, a lot of this is counterproductive because it's going to end up with KYC all over DeFi, and that's going to ruin DeFi. We were kind of saying the courts are where it's going to happen. The courts are where it's going to happen. Well, people have geared up. They're finally now it's conventional wisdom. Now, when you're a contrarian, everybody thinks you're crazy. And now that everybody is doing it, I think they forget that some of us were pushing. But all right, everybody's there now. BA's investing in a great Amicus program. BA's bringing litigation. DeFi education funds bringing litigation. Coinbase and Ripple have been in the fight since the beginning, and they're fighting hard. We might win this one, but the fight's in the courts. The fight's in the courts, totally.
Mm. Hard question for you. Some would say we're in the then they fight you now phase, right? And then
Yeah.
you win. How long do you think this continues, this battle? Is it another 5 years? And then I know you mentioned we talked earlier about it going up to the Supreme Court. How long do you think this lasts?
Well, it depends on whether we have regime change or not.
Mm.
And 4 more years of Biden could kill crypto. Good. That's reality.
But JW, real quick question on that. When you say it could kill crypto, is it certain parts of it? Like they hate DeFi, but they love ETFs, right? They greenlight the ETFs are here. There's going to be campaign donations and pulling the strings a bit, right? And lobbying. So is it certain factions of crypto, or do you think entire crypto?
Um, I mean, you could have the compliance director for Binance could get a wild hair and say, you know what? Delist everything.
Mm,
Uh, and that kills liquidity.
mm,
If the Coinbase case doesn't go our way, it's SCOTUS. I hope it does, but if it doesn't, and the SEC says, okay, shut down operations, that's it. Um, and DeFi protocols that are doxed need to do, like Uniswap, right? We know who runs Uniswap front end.
mm.
If they have to do geofencing, there'll always be some protocol somewhere where I can buy and sell a little bit, but there's going to be very little liquidity there. I can go to ThorSwap, I can go to SushiSwap, but um, the liquidity dries up, and it's hard to sustain with that. And maybe Ethereum and Bitcoin would have a future, but maybe there's kind of a future where they only exist as ETFs, which is that's this is I'm not interested in buying that.
Right.
Um, so but that's the worst case scenario.
Sure.
Let's say 4 more years of Biden and no luck at all at SCOTUS. Worst case scenario. There are other possibilities within that. Like, for example, maybe Biden gets reelected, but we have a strong Republican Senate and Gary retires. And the next SEC chairman has to go through Republican Senate confirmation. So they pick somebody more moderate. Liz Warren doesn't get to pick that time. That could be a not horrible outcome. Um, so I don't know. But for now, for the foreseeable future, we're in court, we're fighting hard.
Yeah, and I hope, the worst case scenario doesn't happen. I think one thing that I really like that I'm seeing is that more members of Congress, younger members of Congress, are waking up to this technology. You got, on both sides of the aisle, Richie Torres and all these guys. And then I was pleasantly surprised by Republican presidential candidates, talking about crypto and what they will plan to do. RFK Jr., who's still in the running as an independent, so just recently put out a video. He's better than Biden for
Yeah.
crypto.
Oh, yeah.
So I guess that's a positive sign, right? What are your thoughts on the impact on politics?
Well, we've got Trump saying better things about crypto than he said in the past.
Yeah.
His financial, whatever you think about him, and there are lots of things to think about him, and I've gone back and forth on this too. Let's set all that aside. His financial regulation picks were all pretty good. Clayton did do everything he could have done for us on crypto, but he did some things that were helpful. Obviously, I have real issue with the Ripple case, but he did give us some guidance about decentralization being useful for getting around the Howey test. He was the only one who let CorpFin put pen to paper on that. That was helpful.
Hmm.
I think he would generally be constructive if somebody like him came in. Or it could be somebody like Brian Brooks, who would be even better, who's very much more crypto native. I'm hearing people speculate Brian Brooks could be the SEC chairman, which I'm saying prayers
That
for
would be
the year
amazing.
or two. Brian Brooks, Chairman Brooks. I mean, that could be the messianic moment in our movement. Um, so it could all work out.
Yeah, that would be
Selling.
incredible.
I'm not selling.
Now, we're talking on the topic of fighting back against the SEC. I would love to get your thoughts on, what we saw in the Kraken versus SEC lawsuit of eight state attorney generals. While not supporting Kraken directly, calling out the SEC, what they're doing is wrong.
Yeah, that's helpful. Those are helpful allies to have. And some of those are some of the leading solicitor generals in the states. And these are some of the same states that are fighting back on the SEC's climate change regulation. The SEC kind of wants to be a climate change regulator now. And there's a big lawsuit pushing back on that. Look, we can win in the courts. The SEC has a terrible record in the courts. They're a bully. They force you to settle. They say they're going to shut down your business. But if you have the finances to fight in court, the SEC has a terrible record at the Supreme Court. I think of the last 9 cases at the Supreme Court, they've lost every one. And some of them they've lost 0 to 9. Like these justices don't agree on anything except that the SEC is wrong. That's the one thing that Justice Sotomayor and Justice Thomas come together on, is that the SEC's positions are ridiculous in some of these cases. So we can win this. We can definitely win this.
For sure. I don't know if you have any thoughts on SOB 121 or 121. I know Congress or the House, they're trying to repeal that. It has to go to vote, but I think it went through the initial phase of repeal.
Yeah, man. Let me plug my newest law review article on this. So I co-authored a law review article with a student of mine, Megan Day, who's a brilliant student. She's going to be clerking in the Delaware courts, and then hopefully we get her in crypto, fighting for crypto. But we co-authored an article called the Mosaic Theory for Major Questions Doctrine Fights Against the SEC, and using SOB 121 as an example. And so basically our theory is this. Most of the time in administrative law, when you're fighting an agency, what a judge will do is say, okay, for this particular thing the agency's doing, is this a rule that I need to review? And they'll have a kind of a focused view of that particular thing. And what we're saying in this article is, no, that's the wrong way to look at this.
Hmm.
Because the SEC's approach to the effort to just kill out crypto, to destroy crypto, is a multifaceted one. It's this guidance like SOB 121, which is just, guidance, but it's still reviewable. We had to get GAO to come in and say it's actually a rule, it's reviewable as a rule. It's the examiners coming in and saying, this crypto stuff, very risky. We discourage it as examiners. It's the cases that they're bringing, the enforcement cases. It's the custody rule, making it very difficult. It sort of says, hey, VCs, use a bank for custody. Never mind that when you go over to the banking regulator says, hey, banks, don't touch crypto, don't touch custody crypto. So this kind of game that they're playing needs to be part of the full mosaic that a judge looks to in reviewing what the SEC is doing in crypto. And hopefully that's a path for major questions doctrine review and overturning of the SEC's excesses here. So go check out this article. It's on SSRN. Download it. Even if you don't want to read it, download it, because my dean keeps an eye on those download numbers. So go check that out. That's my contribution to the fight.
I'll link to that in the description so folks you can go
Yeah.
download to that.
Yeah, it's in the William and Mary Law Review. It's part of a symposium we did where Director Grewal spoke first and told, because he's a William and Mary alum, they invited him to come and speak. And he said, I'm doing everything right on crypto. We're protecting people from, investing in generational wealth here at the SEC. So he spoke, and we did a panel responding, and all the people in that panel wrote up articles about what we talked about. And it was interesting. Director Grual wasn't interested in dissent. So as soon as he gave his speech, he just got out of there. He didn't stay to listen to the counterpoints to his speech. But we made him. And he's going to hear us when some judges start picking up these things and overturning what he's doing. So check
Mm.
it out.
Um, yeah, I'll link to that so folks can check it out. I want to get your thoughts on Fed versus Custodia Bank. Obviously, we had a ruling recently in favor of the Fed, but it looks like Custodia can possibly appeal here.
I hope they do, and I admire everything Caitlin's doing to fight this fight.
Mm.
Uh, Look, the Fed is this all-powerful machine. It's hard to fight the Fed. Believe me, I spent 2 years of my life handling Federal Reserve oversight for the U.S. Congress when Paul Ryan was Speaker. And
Mm.
we had the hearings, and when Janet Yellen was chair, she'd come up, and I was the first. Our committee was the first one to subpoena the Fed for some stuff they were refusing to give us, and they fought the subpoena forever. Um, uh, I led an investigation of some insider trading at the Federal Reserve.
Wow.
We got one of the Fed banks fired, bank presidents fired. So I know this animal, this machine, and it doesn't like accountability.
Mm.
The fact that it can just decide you get a charter or not on the basis of I don't know what. I mean, this Custodia Bank's model is vastly safer than any other bank in the United States.
Yeah.
They don't do fractional reserve banking. That's not a part of their model. Um, so I don't know like this is the one example where a bank charter application is uh, on the risk scale is all the way on the safest part of that spectrum. It's almost like a bank that doesn't do lending at all, that just custodies cash in a vault because it doesn't lend on top of the Bitcoin that it custodies. So hopefully this is the test case to fight the discretion that the Federal Reserve has in chartering.
So JW, question for you, and this may be this is a complex question, but it's things I've been thinking about. So part of that blocking, right, is one, they're trying to slow crypto down, but two, that would change drastically the banking system, what Custodia is doing, if other banks were to copy it. But the system we live in is a debt-based system, and the fractionalization, right? Is it we can't allow this because it can't maintain the status quo? And you've seen how the sausage is made, and right behind the scenes, versus many of us who are watching and listening. So the tough question is, do you see the Federal Reserve model changing anytime soon, or this is how it's going to be for the next 100 years, unless Custodia and these folks and startups can start winning in court?
Um, it's hard because that system is closely intertwined with the banks. The banks are members of the local boards, and they have a real say in who gets to be the regional presidents. And it's hard to change the system from within. I mean, we hear some interesting stuff from like Christopher Waller, who is skeptical of CBDCs and seems to think Bitcoin is an interesting innovation. But he's the lone voice in that whole system.
Mhm.
There's some interesting papers every once in a while from a staff economist who gets it, you know, but that's not enough to have sway within that system. So I don't have a lot of hope. I think we got to build outside of it for the most part.
I, DeFi, right?
Yeah, yeah.
Yeah.
Well, and I mean, the DeFi banks that we have, some of them have survived vastly more stressful events than anything in traditional banking, even in 2008. I mean, I think what what MakerDAO's gone through and survived and thrived despite is a testament to the fundamental safety of that model.
Hmm.
Uh, so yeah, absolutely. If a MakerDAO future MakerDAO future would be based on DAI and is a great future.
Um, as you mentioned, DAI there, just question just came to mind. With the stablecoin wars, we're seeing, Ripple announced they're going to launch a stablecoin. Obviously, Tether and USDC are in the market. I also saw the son of the heir to Van Eck. They're launching a stablecoin as well. What are your
Okay.
thoughts on that? And could we see stablecoin regulations, not so much market structure regulations, but since the Fed is involved, they want to control money. They want to know where every U.S. dollar is going. What are your thoughts on that?
That seems to be the piece of legislation with the most legs in Congress. So maybe it can move, especially because it has some support actually within the administration. But the fact that the administration supports it makes me a little skeptical of what's hiding in there or
Sure.
what the plan is. But look, if Circle gets the charter that they need to help make USDC easier to operate, that's great. Let's give it to them. They've contributed a lot to the ecosystem. Um, I just want to make sure that we still have the freedom to do things like DAI as
Hmm.
well. That any regulation doesn't kill off Maker, while it at the same time helps give Circle what they need to keep moving.
Yeah, for sure. Um, there was a case and it involved Chainalysis, and it's the US versus Sterling Golf.
Yeah.
Tell us about that because you wrote about it as well.
Thanks for bringing that up, man. This has been a real passion project for me. Roman Sterlingoff was a kid who was arrested at LAX 3 years ago. And he was alleged to have operated Bitcoin Fog, which was the leading mixer in Bitcoin in the 20 teens. It was the top mixer. It worked. In fact, the government never cracked it. Never able to trace through um, transactions in the Bitcoin Fog mixer. They arrested him. They said he ran it. Now, he admitted in court he used it. First of all, they put him through 3 years of pretrial detention. So he sat there in a box for 3 years while they went through public defender after public defender. Two guys I really admire, Tor Eklund and Mike Hassard. These guys are kind of the hacker lawyers, which is an oversimplification, but they a lot of hacking cases. They're the leader in that genre. They took this kid's case, despite the fact the government froze all of his assets, because that's the fun trick the government does when they add a money laundering charge to things. They just freeze all your assets.
Hmm.
And so it's hard to get anything but a public defender who doesn't know anything about crypto. But these guys took on the case. And I heard them on a Monero Talk podcast talking about this case. And I read the complaint and I said, this is an injustice. I'm in. What can I do to help? Because I do some forensic accounting and money laundering expert witness stuff. So I jumped in just on the basis that from the face of the complaint, you haven't made the case. The government's theory was this, okay? He says he used the mixer. Roman said he used the mixer. The government could find about $1.8 million of net worth, the most they ever found. $1.8 million. He says, yeah, I used it. I was early to Bitcoin in 2010. It's hard not to get money like that if you're early to Bitcoin in 2010. I mean, you have to try not to get money like that. So I was rich early as a young man in my early 20s, and I stopped working. I used the mixer, and that's it. That's my story. And they said, well, we found a transaction that goes from your Liberty Reserve account out to a Bitcoin address early on. We don't know who controlled that Bitcoin address, but then it goes through a series of transactions, and then it's used later, goes through Orem, goes through no, it goes from Mt. Gox, goes through a bunch of Bitcoin addresses, goes to Orem Exchange, then ends up at Liberty Reserve, then it buys bitcoinfog.com, the domain name. And he says, yeah, he went up on the stand and he said, yeah, I don't know if I think probably I sold Bitcoin to somebody who maybe set up Bitcoin Fog. I'm not sure. I bought a lot of domains back then. It's possible I bought that domain. Just not sure in 2011. And that's it. That's the only thing they had. That was the case. So they pinned Operation of Bitcoin Fog on him. They pinned $300 million of Silk Road and other online drug money went through Bitcoin Fog. They pinned all of that on him. 4 counts. Maximum is 50 years.
Wow.
Uh, I testified. I thought it would be helpful. I testified. I said, look, I spent 30 hours in prison with this kid doing financial forensic interviews. I went through his finances for 10 years with a fine tooth comb and I asked him tough questions. And I went there day after day to the DC prison and asked him some tough questions. He never lied to me. Everything he told me was consistent. And here's the thing. The true operator of Bitcoin fog would have earned, just using the government's numbers, would have earned 24,000 to 36,000 Bitcoin. This guy, you never put in his hands more than about 1,700 Bitcoin. So where's the rest? Where's the other 22,000 Bitcoin? Where did it go? I don't know. I can't find it. And how much is that worth in dollars? Well, it depends on when you estimate. Depends on when you figure he would have sold it. If he held all the way to the top, that's about 1.2 billion. But let's assume he held for a year, 2 years, 3 years on average before he sold. The true operator, and I had some charts, the true operator would have been worth between 100 and 300 million dollars. The government's own forensic accountant looked at this kid and found he never spent more than $50,000 a year. He was never worth more than 1.8 million. So I was there basically to say, as a forensic accountant, this is the mystery of the missing Bitcoin, jury. Where did it go? This would be the most disciplined money launderer in history if he actually ran Bitcoin fog. And then I looked at a few transactions where the government would say, oh, this transaction is kind of complicated, consistent with money laundering. And I was there to say, yeah, I'm glad the judge has decided that this FBI agent who's a year or two out of college is an expert money laundering, but I'm a banking law professor, and I'm telling you, this is not money laundering. This is just a complicated transaction that you would see if you opened up my wallets and put them up on a chain analysis chart. Anyway, it just didn't do it. It didn't do it. The jury was kind of blinded with the pseudoscience that the prosecutors threw at him. It's disappointing, but we're appealing. Mike and Tor are appealing the case. I'm going to help him out however I can, and maybe we'll have better luck on the appeal.
So was it they use some sort of chain analysis data was false?
They had chain analysis do some tracing, and one of the things chain analysis does is clustering. They say these 5,000 addresses are all associated with Bitcoin fog. And when you look at the cluster for any one entity, the cluster of addresses that are clustered together, when you look at the cluster for different tracing firms, the clusters are all different. So the chain analysis one will be this cluster, and the TRM one will have a lot of overlap, but also the circles are like a Venn diagram, more like. So that means somebody's wrong. One of you two is very wrong on your clustering. Clustering's not perfect. It's not to say what they do is not useful in some ways. Very useful to generate leads, right? Who should we go look at? Use your chain analysis tools, do some tracing. Great to generate leads. The prosecutors in this case wrote a law review article for the DOJ law review that said in crypto cases, where they were trying to teach prosecutors in the world, in crypto cases, use tracing to generate leads, but don't use it to attribute illicit funds because it's not precise enough for that. That's what they said. I wanted to use that quote in court and show it to the jury. The judge said, oh, no, that's painting the prosecutors in a bad light. That's prejudicial. You can't do it. Which we were like, Judge, the prosecutor said not to use tracing to attribute ownership of illicit funds, and then they're doing it in this case. Why can't we show that quote to the jury? That's evidence. And the judge said, no, it's prejudicial. That would not be fair to Ms. Pelker, Catherine Pelker, who was the prosecutor in that case. It's frustrating, man. Quite a good fight.
Yeah, for sure. Final item here. Any updates on Zcash?
Yeah, Zcash community is doing great, man. We're transitioned to trustless, fully trustless cryptography. So there's no more trusted setup. Everything's all trustless cryptography with the Halo upgrade. We're going to have you can custody using your ledger or other hardware device now for the transparent addresses. But in any minute now, Ledger's going to finalize the work to do shielded custody using your Ledger hardware device. So that's going to be a big moment for Zcash. We've transitioned to a new base code that can interact with Rust, which a lot of the devs prefer the Rust programming language. So we've got something called Zcash D. We transitioned from Zcash D to Zebra, and Zebra allows Rust-based development. So that's going to open up a lot of new devs for us. Yeah, exciting things going on in Zcash.
Awesome, man. JW, always a pleasure, man. Appreciate your knowledge and insights. We'll probably be talking again soon as
Yeah.
the battle continues with the SEC. But thank you for joining me.
And, hey, thank you for your show. It's the only reason why I know anything is because I listen to your show. So.
Thanks, man. Appreciate that.